Happy Wednesday, and welcome to Illinois in Focus Daily. I'm Greg Bishop, still on the road. Hope to be back at the home studio sooner than later. Appreciate everybody reaching out and sending your best wishes. We got a couple of different issues to tackle today, but both deal with firearms. So the two separate segments coming up. But before we get into those, just wanted to touch briefly on the city of Chicago, with S&P downgrading the city from BBB+ to BBB. What this means, it's going to cost taxpayers more to borrow money in the city of Chicago when the city goes out and takes loans, like they just are looking to do for the CPS budget, Chicago Public Schools budget. Governments typically will help, get across a bridge of funding with borrowing more money, and that all comes with a taxpayer cost. But some people pointing out on X that Chicago's credit rating now, it's right there with Mexico, Indonesia, and Bulgaria. But what exactly did S&P say? I'm just going to read you a quote here. It says, "The downgrade reflects our view that the 2025 budget leaves intact a sizable structural budgetary imbalance that we expect will make balancing the budget in 2026 and out years more challenging." So, kind of one of those moments where you look at it and you're like, duh. I think everybody knows that going into the Chicago City budget. We'll see what the state budget looks like with $3 billion deficit expected, plus continued growing unfunded pension liabilities. So we'll take a look at all of that. But Chicago Mayor Brandon Johnson was asked about the ratings agencies last month whenever he passed that city budget. Here's what he had to say. Thanks to Austin Berg on X for putting this clip together.
I imagine that the Wall Street ratings agencies watched today's proceedings and are perhaps even watching now. What would you say to them as they weigh whether to downgrade the city's credit, which would, of course, cost the city a great deal of money?
Look, we've had 2 credit score upgrades since I've been in office, right? We do know that, the sins of previous administrations, left billions of dollars of debt and left out of here with junk status. We don't want to go back to that, right? We're working to make sure that there are structural shifts within our budget, which 70% of this budget responds to the structural, component, which I think is responsible. I'll just say this, it's important too, and Jill and Annette and Chase and I talk about this quite a bit, about labor peace. Showing some stability there. So, I'm, part of this budget makes some projections for our fire department and EMT. I'm, going to continue to make sure that our folks remain at the table to make sure that our first responders are fully supported. In fact, I'm going to, call Pat today and let him know that we're committed to, finding a solution to ensure that those investments reach the workers of this city. So between the structural commitment that we have to paying into our pension debt, having labor peace, a diverse economy while also making investments, that, I feel good about, how we're moving forward. Now, I think ultimately one of the things I think they're going to watch is what else we do to ensure that you have a progressive revenue formation that balances our budget with more equity. I think that's important, right? So that we don't have these reliances, on more these incremental shifts that we make. So, we're going to continue to show up for the people of Chicago to make the critical investments and then work together to go to Springfield together to fight for progressive revenue.
So there you have it. Just wanted to do a quick little segment there about the city of Chicago's finances and the downgrade that they just experienced. So we'll obviously be watching more of what happens there. It is Illinois in Focus Daily. Like, subscribe, hit that notification bell, and join us each and every weekday morning. But also get the newsletter at thecentersquare.com. The Illinois Supreme Court considering whether to knock down a state law that prohibits open carry in the state. Good morning. It's Illinois in Focus Daily. I'm Greg Bishop. Still on the road, but definitely able to watch what's happening to keep you guys plugged in. So the Illinois Supreme Court hears all kinds of cases that go through state courts. Yesterday they heard a case, Illinois versus Tyshawn Thompson. Now, what happened here was Tyshawn Thompson was arrested in 2020 for having a firearm in a vehicle without proper permit. Those of you who are firearms owners, you know that your firearm needs to be in a latched container if you don't have a concealed carry license. If you have a concealed carry license, it's a different story. But ultimately, Tyshawn was found with a firearm, not in a proper holding, and he didn't have the proper licensing, even though he had a firearm owner identification card. He's sentenced to 30 months. So, case goes all the way through the district courts, the appeals court, got up to the Illinois Supreme Court, and they had that hearing yesterday. Here is Thompson's defender, the public defender, Eric Castaneda from the Office of the State Public Defender, laying out the case here.
Here, Mr. Thompson was convicted under a statute that completely prohibits the public open carry of a firearm in Illinois and that punishes the failure to undergo a double licensing regime under the CCL Act. Neither of these parts of the statute can survive the Bruin test, and Your Honor should find it unconstitutional and reverse Mr. Thompson's conviction for aggravated unlawful possession of a weapon.
Castaneda further develops his arguments as to why the state statute prohibiting open carry needs to be tossed.
We think that concealed carry and open carry are two categorically different conducts, one which is protected under the Second Amendment and the other which is not. So the government can regulate concealed carry, as it pleases, but the same doesn't apply for open carry.
He also provided the Illinois Supreme Court justices some case law that highlights how important it is to distinguish between open carry and concealed carry.
The Alabama Supreme Court in 1840, in State v. Reed, stated that the legislature cannot inhibit the citizens from bearing arms openly because the Constitution authorizes him to bear them for purposes of defending himself and the state, and it is only when carried openly that they can be efficiently used for defense. And so that's a dead ringer that they understood that the Second Amendment only protected open carry.
Now there's a question from one of the justices, Chief Justice Mary Ann Teese, which I think really gets to the crux of some of the argument here.
The original charges were about a drive-by shooting. And there, on the issues about the use of the weapon, the jury was hung, and eventually those charges were dismissed, and all that was left was the charge related to the gun in the glove compartment, correct?
Correct. And that's what I argued below, Your Honors, and I thought that's what the fact should have been confined to. But that was simply not the case. That's not what the court found. That's not what the state argued. The state argued that at some point he possessed that weapon in the vehicle, and Ballark tells us that possessing a handgun in a vehicle, I believe that's a First District case, is open carrying. So we do have open carrying here. And it's really not a factual distinction that Your Honors have to engage in. All Your Honors really have to engage in is whether he was convicted under a statute that prohibits open carry. And that's what Aguilar tells us. That's what Your Honors held in Aguilar, that as long as you were convicted under the statute, then you have a right to challenge the constitutionality of that statute.
So again, that was Eric Castaneda. He is with the state's public defender's office defending Thompson in this case. Now, defending the law is the Assistant Attorney General Garson Fisher. He laid out that, what exactly the state's position is on this case.
The court said in no uncertain terms that shall issue licensing regimes, including explicitly Illinois', are constitutional.
Fisher also spelled out what he believes is the makeup of the Second Amendment and what exactly is covered by the Second Amendment.
The defendant's conduct here, the unlicensed carriage of firearms, when the licensed carriage of a firearm is readily available to all ordinary law-abiding citizens, is not covered by the plain text of the Second Amendment.
Now, one of the arguments was Illinois has a dual licensing scheme, a two licensing scheme. If you want to be able to buy and possess firearms and ammunition, you need to get a firearm owner identification card. If you want to carry it out in public, concealed, you have to get a concealed carry license. Some of the things that Castaneda was saying, Illinois has this two licensing scheme here, where it really is hindering individuals' ability to exercise their Second Amendment rights, even to open carry, because, they can't defend themselves without getting permit by the state or facing, criminal penalties. But you've got the state's Assistant Attorney General, Garson Fisher, spelling out what he says is, it's totally legit and constitutional to have this scheme.
And the mere fact that a FOID card is a prerequisite to subsequently acquiring a concealed carry permit doesn't make Illinois' system an infringement on the right to carry firearms. And the court was explicit that things like fees and processing time, and even explicitly firearm safety training, which is one of the aspects of the CCL Act that is different than the FOID Card Act, are not infringements on the Second Amendment right to carry firearms. So the mere fact that there is a second licensing requirement, so to speak, a prerequisite license to get a CCL, doesn't make Illinois' CCL requirement an infringement on the right to bear arms.
Garcon also gives some recent case law that he says builds their case to defend the prohibition of open carry in the state of Illinois.
The Fourth Circuit upheld a dual licensing regime in Maryland. The U.S. Supreme Court earlier this week denied certiorari in that case. So I don't think there's anything about the prerequisite that you have a FOID card that makes Illinois' scheme unconstitutional.
Now, as these cases go, you have the appellants, the appellees, and then the appellants give their rebuttal. Here's Castaneda with his rebuttal.
In Bruin, that statute did not completely ban people from possessing guns in public. It simply required them to, show a heightened sense of self-defense, which was found unconstitutional. But it wasn't a complete ban on carrying firearms, and yet the court found that was an infringement. In Rahimi, the court quickly went past the first step to the second step to find that the Second Amendment was implicated. And for all these reasons, Your Honors, we ask that you find that the AUPW subsections A1 and subsections 3A5 are facially unconstitutional, and that you reverse Mr. Thompson's conviction for aggravated unlawful possession of a weapon.
We'll be watching for whenever the Illinois Supreme Court makes a ruling on this case, but clearly it's going to be an interesting one, as it could be a few months. But of course, you can go watch the entirety of that hearing. You can find the Illinois Supreme Court's streams. Just go to their website, and you'll be able to enjoy all 45 minutes of the debate back and forth on that issue. It is Illinois in Focus Daily. Like, subscribe, hit that notification bell, and join us each and every weekday morning. And get the headlines in your inbox at thecentersquare.com. Cook County is apparently continuing taxing firearms and ammunition despite a circuit court judge siding with gun rights advocates earlier this week. I've got reaction to some of that. It's Illinois in Focus Daily. I'm Greg Bishop, and you should get the podcast. All right, anywhere you get podcasts. If you can't make the program each and every weekday morning on video, you can listen to it. All right, so find us with Illinois in Focus. But you can also get the headlines in your inbox at thecentersquare.com. So yesterday we shared a conversation with John Bach from Gun Save Life. They had a case that they brought against the Cook County gun and ammo tax that was enacted back in 2012. And several groups sued, Gun Save Life, one of them. That case stemming after the Illinois Supreme Court ruled against the gun and ammo tax, and Cook County modified their ordinance to continue the gun and ammo tax. So here we are now 4 years later, and we get a district judge ruling siding with the Gun Save Life group. So we talked with John Bach yesterday. If you didn't get a chance to see that, I encourage you to go check out that video. But I connected with Dan Eldridge. He's with the Federal Firearms Licensees of Illinois, and also with Maxson Shooters Supplies and Indoor Shooting Range. And he said that the ruling, it took a while to get to it.
Well, it's thin and ambiguous and took almost 40 months to produce.
Eldridge, being a firearms retailer with an operation in Cook County, talking about the collection of those taxes and how this is impacted. He gives a lot of history here. It's important to hear him out.
Right. More than the retailer, we're also a plaintiff. We were the sole remaining FFL plaintiff in this case. So let's talk about the history of it. It started in the trial court, where we lost, went to the appeals court where we lost, and they bounced us out as a plaintiff. And then it went up to the Supreme Court, Illinois Supreme Court, where we won, and they decided the case on the uniformity clause issues and stopped there, saying, well, we found it unconstitutional, so we're going to stop. And they left all the 2A, RKBA issues aside. Curiously, Ann Burke, the Chief Justice, stepped out during the orals and recused herself. To this day, we don't know what her conflict was, which is a pity because I think she was a reasonably good, by Illinois standards, pro-gun justice. So in a I wouldn't call it a dissent, but in a commentary, I believe it was Thomas Burke who pointed out that this was a foolish way to rule on it because the county would just go and pass another ordinance that comported with the uniformity standards or the uniformity clause of the Constitution. In any event, the Supreme Court kicked it back down to the trial court with instructions to grant us, the plaintiffs, our summary judgment. And in the 20-some days between when they made that decision and sent it back down, the county monkeyed around with the language a little bit and said, okay, well, we've addressed the uniformity stuff, so, all's good. Well, that's not really the way the world works, but that's the position they took. So we had a brief window when we were not collecting the Cook County tax, and then they instructed all the FFLs that, no, we made these changes, so now you have to collect them again. And then we sat and waited for almost 40 months for the judge to do what his bosses told him to do, which is issue us the summary judgment. So here we are, a very thin order because it doesn't really set forth any remedies. It says, give us our summary judgment, but what does that mean? What's enjoined? Who is enjoined from doing what? What version of the language is it that's enjoined? So we're sitting here in limbo. So in answer to your question, as a retailer, we are continuing to collect the tax pending understanding from Cook County about what they intend to do in this matter. Do they intend to continue to try to enforce it? Are they going to appeal this? What are we talking about here? Will they try to just crank out another gun and ammo tax? It's a different world now than it was back in, 2021, in a couple of respects. First respect, the makeup of the Illinois Supreme Court has changed significantly. So that works against us if this does get litigated again. But more importantly, you've had Heller Brewin and a bunch of pro 2A, pro RKBA cases decided by superior courts, which will make it much more difficult for the state to, or for the county rather, to defend something like this. So my hope is that they, in discussions with our attorneys, conclude that this is a Sisyphean task that they're undertaking. It's a further waste of scarce and dwindling county resources. And the reality is this hasn't had any meaningful impact on safety whatsoever, and it's cost the county sales tax revenue from the economic standpoint.
Now, what about customers? Do customers want to go to a Cook County retailer to purchase firearms with an additional $25 tax on each firearm and a 1 to 5 cent tax per round of ammunition? That all adds up really quick. How does that impact the consumer in all of this?
Well, we have to make up for it however we can. The ordinance itself says that we can't just embed the tax in the price of the firearm or in the price of the ammo. It has to be called out as a line item on the receipt. So that means that we can't just consume our margin to collect and remit the tax. So we've had to, first of all, as a retailer, we try to provide a superior service level and a superior environment for people to shop and shoot in. And so that we're not necessarily competing on price with for example, internet sellers of firearms. In a lot of cases, we'll be close, but we will have that $25 tax on top of that. So we have, it's also a significant issue for ammo sales. remember, this doesn't really scale with it doesn't scale at all. It's a fixed price tax. And so when a box of 9mm range ammunition is $15, that $250 is quite a bit more significant than, during the pandemic when it was $30 and $40 box. We have always provided a range pass with every firearm purchased. So, there's your $25 back. That's a longstanding policy at Maxons. But in addition, it's a significant amount of work to produce these returns every month. I mean, it's probably the better part of a man week to do this. And so, yeah, it certainly hasn't helped us. And I would like very much to have all of that work go away.
Anything else top of mind with this issue that you're at least looking out for in the weeks, months, years ahead?
Well, I think in days or weeks, we should have clarity with where this is going to go. And are we going to have to relitigate this for another 6 years? Part of me thinks that maybe Cook County doesn't want to be the test case in an ammo tax that gets held up or in a gun and ammo tax that gets held up as it's not a precedent, but it's certainly a parallel opinion for all the other states, cities, municipalities that are contemplating or implementing gun and ammo taxes. So, just like with concealed carry, they didn't appeal it all the way up to the Supreme Court because they didn't want to be the ones to be in the law books. Maybe that works to our advantage. I don't know. I do think that we should have some clarity on which way this goes in a matter of days, if not a week or two.
So again, thanks to Dan Eldridge from Maxon Shooters and also the Federal Firearms Licensees of Illinois. They're involved in a lot, including the challenge against Illinois' gun and magazine ban, which is still out there pending. We've got a lot more to share about conversation I had with him. So be sure to like, subscribe, and hit that notification bell here with Illinois in Focus Daily. But back to John Bach. Yesterday when we chatted with him, it wasn't clear yet if Cook County was going to cease or continue to tax firearms and ammunition. Well, the word is now that they are going to continue taxing firearms and ammunition. Does that mean they're, as Bach says, going to continue being stupid?
I think ultimately, if Cook County wants to be stupid about this, we're going to be looking to the U.S. Supreme Court to strike down these targeted taxes of gun rights nationwide, and that's going to be a kind of an embarrassment for Cook County to be responsible for the end of this tax on guns and ammo that are commonplace in some of these other states like California and New York.
A lot more to say about that case, no question, but wanted to give you those updates as we get them here with Illinois in Focus Daily. Like, subscribe, hit that notification bell, get the podcast where you get podcasts, and we'll see you soon. All right, again, guys, thank you so much. I'm Greg Bishop. Got to get out of here and get back to covering some things and watching what happens with a variety of different stories. The governor's got an event today. He's got a couple of more Supreme Court cases that are going to be heard on different issues. And pension audits that have come out showing the state's unfunded liability and how much taxpayers are on the hook for. These are just some of the things we're going to be monitoring over the next 24 hours and keeping you plugged in. So get the headlines at thecentersquare.com. Have a great day.